Thank you guys so much for joining us today. I am here with our PLG attorneys, here with Ruby Powers and Cynthia Milian. Woo, yay, thank you. Today we're going to be talking about the conditional green card and the I-751, which is conditional green card. Our attorneys are gonna use their expertise to further explain this topic. And if you guys have any questions, you guys are more than welcome to ask questions in the Q&A down below, and we will answer them at the end of this presentation. So first off, with our very own managing attorney, Ruby Powers, she has had the firm since 2009. She is part of the AILA Law Practice Management Chair, also HBA Law Practice Management Section Chair, and she's the author of Build and Manage Your Successful Immigration Law Practice Without Losing Your Mind. Keyword, losing your mind, ladies. And we also have our awesome assisting attorney, Cynthia Milian. She focuses on family-based removal defense and immigration. She serves as the vice president for MABA, the Mexican American Bar Association for Houston, so super cool. And she's also a pro bono attorney for the Montgomery County Immigration Law Clinic. So thank you so much for all the work that you ladies do. So yeah, today we're going to be learning about the conditional green card. Ladies, will you all take it away?
All right, thank you so much, Dana. And just to clarify, this presentation is after you've already received the conditional green card and you're concerned about removing the conditional restriction, we're getting the permanent green card. So we're going to cover all the things you need to know about the I-751 after you already have received your conditional green card and maintained it. So we'll go ahead and dive in with some of our learning objectives. What is conditional residency, the requirements for joint petition, timing, dependent children, late filing of the I-751, waivers to the joint filing, good faith marriage, battery, cruelty, hardship, death of original petitioner, proof and timing issue. And we're also going to mention a little bit about immigration court matters and Q&A. You can always put a question in our Q&A, and if we can answer it live, we will, or we can chat back, or might require a consultation. Thank you so much for joining us today. So what is conditional residency? It was created after the Immigration Marriage Fraud Amendments in 1986, and I got married to an immigrant in 2002. So the movie that was really popular around that time-ish, the one that was The Green Card with Gerard Depardieu. And I didn't have an immigration attorney. I got married in college. And so almost everything I thought I knew about the I-751 process, I mislearned from watching this movie, which I wanted to bring this up because, you know, immigration is usually so serious, but that was a big impression on me, and here I am providing free information to people. I'm really glad that we can give this information, because you don't want to do whatever you learned from the green card or the proposal that came out. None of that stuff, you know, that does not give you good advice. They're making Hollywood movies out of this stuff. So I'm just gonna say, don't do what I did to think that that's how things worked. But the gist of it is that if you got your green card based on marriage, so U.S. citizen, legal permanent resident, and it's been under 2 years, when you receive that green card, you will have to remove that condition within 2 years. There's some exceptions to that you could do it sooner, and then once you remove the conditional part of the green card, then you will get the permanent one, which is for 10 years at a time. And so that's the gist of it. The conditional residency has some limitations. You have to remove the conditional residency part by filing the I-751, and if you don't, there could be consequences later on if there was a USCIS error, or somehow that gave you a 10-year green card instead of a 2-year green card. We've seen that happen several times. where people go all the way to naturalization and then find out there was a mistake and then they really should have filed one somewhere along the way. And just in general, until you're a U.S. citizen, keep proof of documents of your relationship and as much as you can about your immigration history. Anything else you think we should add about this, Attorney Milian?
I think you've covered it all.
Okay. So, I mean, and also that proposal movie, oh my gosh, that was the most recent one. Like, really, an officer you don't get to walk in and talk to an officer on day one, and they do not fly to like Alaska or wherever to visit you that same weekend. That doesn't happen. Anyway, sorry, I guess I had to get that off my chest. So, the requirements, when you look at the I-751, there's a couple of boxes you could check off of why you're removing the condition so you're eligible. And one of them, in the joint petition, is when the couple is still together. They're living together, they're a couple, they're being married together, and they have proof of the relationship. And so the bottom line with this is that it's a lot like getting the green card in the first place. Taxes, leases, insurance, life, health, auto, photos, as much of that as you can organized. And you can file it as early as 3 months before the conditional green card expires. Don't file it earlier than that. I always go to timeanddate.com and I figure out what that date is, 90 days before it expires. So I usually try to get it in early, but not before you possibly can. So 90 days. And it's the form, the filing fee, and the proof of the relationship. We submit it with an index and organize that evidence to make it as easy as possible. Usually what we find is that with the joint petition, there usually is no interview. Sometimes there is if there's something that they have a question about. But that's the bottom line. So, in immigration law, the marriage is considered bona fide if at the point of inception, when they said I do, that they thought it was going to last forever, even if it doesn't. But that is really one of the tests for immigration. And, relationships come in all shapes and sizes, and people can be traveling and living in different places temporarily because of work and school. But you ultimately want to prove that you've been commingling funds, living together, and doing what they consider most couples do. The consequences of not filing timely are that you could risk getting yourself put to immigration court. We had that happen for one of our clients that filed it late and for some reason got sent to immigration court. It took a little extra hassle, but we were able to resolve that. But you just don't need to do that. And if you have good reasons, we'll talk about that. There are ways to overcome filing it late. And the other consequences could be you could be put in court, you could have problems later on for naturalization if there was a mistake in whether or not you needed to file or not. And I included this little photo down below. I know I'm being silly today, but I really remember this photo from like 20 years or I don't know, 15 years ago, because they were making photos. Look, see, they're like in downtown New York and they're taking photos as if they're skiing. So please don't do that. Again, don't do what they do in these movies. Just be normal. And what we see for a lot of our clients is they don't ever print the photos. People take lots of photos on their phones and they never print them. But this is the one time when you probably are going to print them. But anyway, we're moving on. So, and that's a little bit about what we talked about, is that you need to file it within that 90-day window beforehand. And that's really important. There's exceptions with the waivers. And the other thing is a conditional resident doesn't need to be present in the US to file, but they must attend the interview if it's scheduled. So we've had some clients be abroad when this was happening. And there is no limit to the number of I-751s a petition can be filed, and we've seen that happen with a few people, because a person might file a joint filing and then the relationship falls apart, unfortunately, and then they need to do a waiver. We've had some people we've known file maybe 3 times for different reasons, situations, but it's just more time and money. So that's just some considerations. And I can talk a little bit about children as well, is that children are also subject, dependent children are subject to the conditional residency. They would be included, they may be included in the jointly filed I-751. We have, you can include them if they're within a certain period of time. Very often the parent and the children get them at the same time. There could be some times when they don't. You just want to make sure that you file them 90 days before it expires. But ideally, you're filing them concurrently in the same I-751. And you just need to make sure that there's filing a biometrics fee for the dependent children regardless of age. And if there's no concurrent acquisition, if the parent is deceased, if the parent is divorcing, or if the child is separated, then the child may file his or her own separate petition. We've seen that happen as well. So they just would need to make sure that they take care of their own petition, but don't think that just because something happens with the parent that automatically takes care of the child. Make sure that this is where we would include when things get a little messy here, make sure to get a consultation, make sure you have competent immigration advice letting you know what you need to do.
And then I just want to say something quickly.
Yeah, go ahead.
I think you talked about it briefly about the separate biometric fee. So I do want to point out that the filing fee right now for the I-751 is $595 plus the $85 for the biometrics, but that will go up to it's going to go up to $760 after October 2nd. And the biometric fee is not included in that. So just keep that in mind if you're filing something after October 2nd.
But the biometric fee is going to go down to $30, right, for the non-DACA? Mm-hmm. So I did the math, I think yesterday, if you count the biometrics going down, but the I-751 going up, it's only around like 100-something increase after October 2nd, if that's the right way that I'm interpreting it. But that's a really good point where you've been bringing to light on a lot of our webinars, the filing fee is going up. And there's a lot of changes too about biometrics fee, and just make sure, usually when a child is under 14, you don't do the biometrics, but in this case, you need to. So you need to make sure you follow through. And if you send the wrong biometrics number, they can reject it. And then you could waste a whole month because that's what USCIS processing time is happening right now. So, Attorney Milian, do you want to cover a little bit about late filing?
Yes. So at the beginning of the presentation, Attorney Powers talked about how there's some exceptions to filing a late I-751. So, you want to make sure that you get it in on time, the 90 days before your green card expires, your conditional green card. But if for any reason you do have to file it late, then there are some causes or reasons that you can show. For example, if you were hospitalized, if you suffer from any long-term illness, if there was a death of a family member or the recent birth of a child, all of this has to be, you have to include evidence, right, to support all this, because you want to show them, like, for example, if you get referred to court, you're still going to have to file the I-751 with USCIS, but with proof of why. So if it was hospitalization, then you need to have those records that you were hospitalized. If you had an illness, then maybe doctor's notes, including and demonstrating the reason for the late filing. Also, if you're in the military, just proof that you have a family member that's serving or in the active that's serving the military, along with that late filing.
And like right now, USCIS is allowing 60-day extension, but that's specific to requests for evidence, notice of intent to deny, notice of intent to revoke. I forgot what the other one, denial, I think. But you don't really want to risk it, because if you get put in immigration court, you have to go, and the rules of court are different. And it can be really annoying. And now you could have a really good reason, and they might not have sent you to court, and that's great. The one other key thing you need to know about late filing is that you have to write in the application, please excuse this late filing. There's something along that line of language. There's something in the regs that basically say that that has to be included for them to accept. And I think the longest we had somebody file late was maybe 7 years. That might have been a few years ago, or maybe even more. I think we have a new person in the running for the longest they went. Unfortunately, they found out when they were applying for naturalization that their parent hadn't filed this, and so now we're doing it after the fact. But if you have good reasons, and the other thing I'd say, a lot of people, when they have consults with us, they really don't pay attention to that expiration date. So put a tickler somewhere, think about maybe 4 months before it expires. That's when I usually like to get hired within a month before we can file, and make sure that you don't file it late. So do you want to talk a little bit about waivers?
Sure. So if for any reason you're not able to file jointly, like Attorney Power says, if you've divorced or if you've been a victim of domestic violence or you've suffered battery or extreme cruelty, then you can file that. You don't have to wait for the 90 days before the card expires so that you can file that. But along, just as with late filing, you have to include, if, for example, you were a victim of domestic violence, right? You have to include police reports. If you went to a psychologist to get an assessment or therapy, all of that information has to be included so that you can prove, not only do you have to prove that it was a valid marriage, but you also have to prove that battery or extreme cruelty. There's also, you can also do it under extreme hardship. If, for example, you're married or end up getting divorced, if your children will suffer extreme hardship, if you are asked to leave the country, then you have to include proof and information of that as well. So there's also, if, as we talked about, if the marriage ends, and you're divorced, and you have to include proof of that divorce decree along with the I751. And you can mark off on the I751, the application, the waiver in which you're requesting.
That's right. So just, it can get a little confusing. So we'll go into a little bit more detail on each one that we've mentioned so far. So good faith marriage, one of the first waivers that we see most commonly is that it was a good faith marriage, bona fide, when they said I do, but it didn't work out for whatever reason, and it was terminated. So this is where things get really a little bit hard, because a lot of times couples are trying for things to work out and they're not at the divorce part yet. They're trying to do counseling, they're trying to see if it's going to work. And then those 2 years, maybe things are getting rocky for some couples, but they just haven't gone all the way to termination. So the good faith marriage, it would be that you're not filing it together. The immigrant is signing and filing on their own, but you're showing as much proof of the relationship. And you ideally already have the termination, the divorce decree, like Attorney Milian was mentioning, but in many cases we find that our clients are still in the process of the divorce. And in Texas, the fastest divorce you can have is 60 days legally, but practically we're dealing with COVID, and courts have been limited. I think courts are trying to open up, even jury trials and things like that are opening up. But for the most part, I think a lot of family lawyers and family judges have been focusing on emergency matters and emergency child support issues. And so some non-considered emergency matters might be taking a little bit longer. So what we generally do would be file the I-751, letting the USCIS know that they're in the process of the divorce, but then would be asking for a request for evidence to submit that further. But it's the burden of the applicant to prove the relationship and the validity of the marriage. And a lot of times when things are not going well, the other spouse might start blocking off access to documents and online accounts that would prove the relationship. So we usually tell, when we have consults, to start explaining things that they should be considering in collecting documents, even if it's too early to file. The other thing to note is that if the divorce is finalized at some point in that 2 years of conditional residency, you don't have to wait until 90 days before it expires. You can file earlier. That's I think a little unknown fact. So if you had the divorce finalized within the first year, you can actually file the I-751, but you just need to make sure you have a lot of proof of the relationship. And the other thing about battery and cruelty, it's like a very similar concept of Violence Against Women Act. So you, a couple of things to note: you do not need the divorce or termination. So that shouldn't stop you from filing it. And the other thing to note is that if you do get it approved under this provision, you can apply for naturalization under the 3-year rule instead of the 5-year rule. So sometimes we've had cases where we check off good faith marriage and battery and cruelty. It's just important to note which provision it was approved under. And we've had cases where couples didn't live together very much, or they lived in hotels, or they lived with other family members. We've still been able to get approved. I will just say that most cases of good faith, these waiver cases, in general, I find USCIS takes almost 2 to 3 years to approve, unfortunately. But if anyone tries to stay together just so they don't have to apply for the waiver, that's never a good idea. So I just want to say that if it's a true relationship and you qualify under these waivers, it'll run its course and you'll eventually get the right adjudication eventually. But you just have, a lot of times I see our role as being like a coach and guiding people through, because it can be very painful to go through this process. Anything else, Attorney Milian, on battery cruelty? But you can check off multiple waivers.
Right.
And if you do use this provision, you don't need a divorce decree. And if you do check this off, you do need to have a very, I'd say, extensive affidavit of the abuse.
I will say that we, and this is why it's important to have an attorney. We have had cases where the couple is together and they file one jointly. And while that's pending, because it could be pending for 16 to 18 or more months, things happen, right? They can either get a divorce or things just don't end up well. So then we've had to file an amended I-751. And, that has gotten a little tricky. So it is possible when you already have an I-751 pending to file a subsequent one with a waiver.
That's a really, really good point, because that's what we see very often, is that they file a joint filing and they have an attorney for that joint filing, and then things are not working out. And then they get a consult with another attorney, because you have to remember there's confidentiality, conflict of interest matter. And so the attorney that filed for you joint cannot be the same attorney that files for you if you're separate, unless the bar allows it and the couple allows it. I mean, it's very rare for that to happen. So you generally would want to have a consultation with another immigration attorney. But if you have to amend it, you don't have to, if it hasn't been adjudicated the first time, you can still amend it and you can retain that filing fee. You don't have to file a whole nother I-751. We've done this countless times. And you can even amend it in the interview as well if you have to. So the other waiver is the hardship waiver. So if if it's not easy to prove the other waivers, you can show this. This doesn't require that the marriage was in good faith. I think that you have to be very careful though, because there's a lot of consequences of marriage fraud. So this is probably the waiver we do the very least, if not much at all. And we try to have everybody meet the other requirements we've already explained, but this does exist. And this might be for someone who has like more of a, like asylum-ish type of a situation, can't return back, and also maybe just can't prove as much on the relationship side for whatever reason. So the other thing to mention is the death of the original petitioner. So you can, no separate waiver is required, and excuses the joint filing. The non-citizen spouse must comply with the other requirements of the joint petition. So you would just file a joint petition even though the petitioner is no longer alive, and show as much proof of that relationship as possible. So proof and timing. So let's talk a little bit about that. And we are getting sort of to the close, but feel free to put any questions you might have in our Q&A box. So USCIS may not deny a petition solely because the spouses are separated or have initiated divorce or annulment proceedings. They must provide the actual physical address of each spouse and the divorce decree. And this is what we were mentioning. We asked for requests for evidence. I feel like I've had a lot of consults about I-751 this year. That's why we did this today. And we've seen cases where people filed jointly without an attorney and things were not still together by the time they had an interview or soon after. And then it got denied. You never want to mislead USCIS. You always want to tell the truth. And if you have to file an amendment or you have to file a new one based off of the waiver, you've got to do it. So you just got to do it. And I think a lot of people don't understand how that works. And then in terms of proof, it's the foreign national or the immigrant has the burden to prove it was established a good faith marriage. And some people have lots of different relationships where they keep separate bank accounts because they had prior marriages, or they don't have a credit card together, or sometimes they're living apart for career or school. You just have to be able to, it's your burden to prove that's still a good faith marriage, even if it might not meet the standard. The image that USCIS might hold. So if you don't have that perfect picture image that USCIS thinks is marriage, then you need to make sure that you can try to overcome it in other ways. And the other thing we do a lot with the I-751s, especially for the waivers, is we have the immigrant write down an affidavit explaining where the relationship started, how things were going, and then the eventual fall, and the lack of evidence that they may have with they are missing some information and evidence. So the affidavits from individuals who are familiar with the relationship are very important, like friends and family. If you need to do that, use that to explain more of the absence of evidence and to explain what was happening in that relationship. Anything else do you think we should add, Attorney Milian?
No, I would just say to document everything from the moment you file your AOS, if you purchase a home, anything, so that you can include that from that moment during that period that you receive that conditional card. So
immigration court. So let's just say a couple of things, and we're on our last slide before the Q&A. If your I-751 gets denied by USCIS, you still could file another one with USCIS before you get put in immigration court. But you would need to do it before they send you a notice to appear, and then immigration court has jurisdiction. Another thing to note is that the immigration judge cannot review an I-751 that was already reviewed by USCIS for the first impression. For example, if a couple files a joint marriage filing, and then it gets denied because the couple is still not together after a year or two of filing, then the immigrant can file a waiver of good faith marriage and needs to file it with USCIS. USCIS must review it before a judge can review it, because that was never filed before with USCIS. So bottom line, I hope that's making sense. The judge can only look at something that was previously reviewed by USCIS. The other thing is if a person gets put in immigration court and they haven't had the opportunity to file that new version of an I-751 that was not previously reviewed, the judge will hold the case and give continuances until it is adjudicated with USCIS. And it could be possible that it can still could run its course, and you can still get approved. It's just that it's very important that that is adhered to, because the immigration judge can only look at what hasn't already been reviewed and decided by USCIS. Anything else to mention? And when things get to immigration court, you have to change your address within 5 days. There's trial attorney, a judge, there's different reporting, and there's hearings and things like that. It still can be overcome. It's just a matter of sort of the rules change a little bit in that respect. And I think there's one thing we forgot to mention is that when you do file an I-751, when you have the application, the filing fee, and all the supporting evidence, whatever, if it's a joint filing or waiver, is that you will get an 18-month receipt validity. And so what happens is that your card will probably expire or has already expired at some point, but you'll have that 18-month validity. And for our clients who are still married to U.S. citizens or spouse, and you can use the 3-year provision for naturalization. If they meet all the requirements, they can actually apply for naturalization while their I-751 is still pending. We've done it before. We're probably going to see a lot of that more now that I-751 seem to be taking quite a long time. The other thing that's important, so I hope that was clear, you can actually apply for naturalization while your I-751 is still pending. They can actually adjudicate your I-751 and N-400 at the same time in an interview. But you definitely have a consultation with the immigration attorney to make sure that that works for your case, and you want to make sure that you have proof of the relationship, because you're applying for I-751 on a joint filing, and you're applying for naturalization based on the relationship and the proof of the relationship under that 3-year provision. And I think there was one other thing I wanted to mention, but what are some other closing thoughts about I-751s, Attorney Milian?
Yeah, so if, as you were saying, if for any reason your I-751 is pending longer than that 18-month extension, there are ways that you can get a stamp with USCIS, but there are very limited reasons. And you have to show the proof if it's for, economic loss, or if you have to travel outside of the country, then you have to show the proof of that need. So there is a way to do that. And I would just say that I-751s are tricky. So definitely consult with an attorney if you are finding yourself in trying to decide under what basis you need to file that I-751.
That's right. I think even if you're considering filing it on your own, just make sure you have a competent, experienced immigration attorney who gives you a consult, that you schedule a consult with, to make sure you're on the same page. And just that they can take a while, and USCIS is getting a little bit more backlogged with COVID right now. So we just have to all be a little bit more patient than we were before. But so if you remember anything, just remember, don't do like they do in the movies of the proposal and green card, and feel free to give us a call at 713-589-2085 to help you understand what to listen to, what not to listen to, and how this works. But hopefully this was helpful. This is online and it'll be shared. People have access to it, so you can share it with your friends and family or reference it later on when it applies to your case. And we really appreciate you watching us. We are going to have more webinars every Friday. And Dana, I think I'll let you take it away, letting people know how they can stay connected with us and find out what the next programming is going to be.
Yeah, of course. So actually, very quickly, they left a question here on our Facebook.
Oh, okay.
So the question is, let me get to it. The question says, if I got married in Mexico, does that still count? I am a US citizen. So I'm guessing that they got married in Mexico with their spouse and they're trying to do this whole green card situation. What do you think, Ruby?
The short answer is if the US recognized, if it was valid at the place of inception of where the marriage was created, then it's valid in the eyes of USCIS and the US federal government. So that's the short answer. So we do get asked about that, like, well, I got married in another country, so it's not real. And we're like, nope, it's still real. So if you did marry somebody in another country and you're not wanting to be married to them anymore, you need to make sure that you divorce them legally, because we've had cases where people think, maybe I'm going a little bit on a tangent, but not so much. We've had people think that they were married to someone, but they found out they were really still married to the last person. And so that is a really good question, because this is where it gets a little complicated with international law. But the U.S. also recognizes same-sex marriage. We pretty much recognize almost anything as long as it was valid where it was initiated. So there is a lot of guidance about the Foreign Affairs Manual, which is more for jurisdiction for State Department, but that's where we get some of our guidance as for USCIS as well, and how we review reciprocity of documentation in foreign governments issue for marriage and divorce. But yep, you're legally married. If it was legal there, it's legal here.
Okay,
short
and
answer.
Another one.
Okay.
So let me get to that one. The other one says, if I'm currently in the process of divorce, you might have already answered this, but if I'm currently in the process of divorce, I'm on the ends of it, am I able to start this process with my newly spouse?
Well, I would say have a consultation, but you can't petition. So the other thing that goes on in Texas is you can't legally marry, and maybe this person's in another state or country, whatever. But in Texas, you cannot marry someone else unless it has to be 30 days between divorce and marriage. So you might have the intention of divorcing your first spouse and marrying someone else, but you just need to make sure that the spacing of that timing is legal, and also it can look really suspicious depending on what's going on. A lot of times people don't review the divorce decree, but the divorce decree almost always has a date when the couple stop living together. I always look to that date because you want to see what was going on. And a lot of these I-751 cases, it's almost inevitably, I'm just doing a timeline. When did you get married? When did you stop living together? When did you get divorced? When did you meet the next person? And so on. So maybe I'm talking too much about that, but I'd say have a consult, and it could be possible. It's very likely possible. It's just a matter of being careful with what you do with your timing and making sure nothing looks fraudulent or is fraudulent, So that's our concern.
Well, yeah, that's about it. Thank you guys so much for joining us today. You guys got some pretty good information from our very astute attorneys. So please be sure to let us know if you guys want us to speak on another topic. As you guys know, we have these webinars every Friday. Our upcoming webinar for next Friday is on rare alternatives to immigration. And then on October 2nd, we're going to have how to improve your success in an asylum interview and or hearing. So really good stuff, guys. So be sure to tune in and check those out. You guys can register on all the upcoming ones on our website. You guys can also subscribe to our newsletter. You guys see the link down there below. If you guys check out our website, it'll pop up there. So it makes it really easy for you guys to just, submit your information and subscribe to that newsletter. But if you guys have any other questions or concerns or would like to schedule a consultation with our attorneys, please do feel free to give us a call at 713-589-2085. And you guys can also send us an email at contact@rubypowerslaw.com. And feel free to check out all of our social medias. Me and Ruby are doing this really cool talk show type of deal on Tuesdays where we tackle some immigration topics and just, you know, answer those questions on a one-on-one basis with our attorneys. So it's really cool.
That's
really
Tuesdays at 5 on, you can find us on Facebook Live, and you can ask us pretty much anything that's related to immigration, and
Yeah.
we'll try to answer it for you.
Just call in and let us know that you're calling for the telecast, and we'll be sure to direct you promptly. But again, thank you guys so much for tuning in with us today. It was our pleasure, and we all hope that you guys have an awesome Friday and a very safe weekend. Be sure to mask up, ladies and gents. And well, bye
right
guys. Thank you so much.
Right. See ya. Bye. Be safe.
All right, so
I gotta thank you.
Alrighty, ladies, bye.
Bye.